look at a key case in tort for the area of negligence, looking at a duty of care. This case is Donoghue and Stevenson, and it was heard in 1932. In this case, Mrs Donoghue and her friends were in a café in Scotland. Mrs Donoghue's friend bought her a bottle of ginger beer, which was contained in an opaque bottle, so Mrs Donoghue couldn't see the contents. Mrs Donoghue started to drink the ginger beer, and after she had consumed some of it, poured some more out and realised that it actually contained a decomposed snail. Mrs Donoghue, unsurprisingly, suffered from an illness as a result of drinking the contaminated drink and brought an action against Stevenson, who were the manufacturers of the drink. This case is a key case in establishing a general duty of care. In this case, Lord Atkin stated that you must take reasonable care to avoid acts or omissions which you will reasonably foresee would be likely to injure your neighbour, and therefore established the neighbour test. This means that a defendant will owe a duty of care to their neighbour. So who is your neighbour? A neighbour is someone who is so closely and directly affected by your actions that you ought to have them in mind when you are acting. So if we apply this to the case of Donoghue and Stevenson, in making the drinks, Stevensons have to have in mind the end consumer. That is their neighbour. Therefore, in this case, it was established that Stevenson did owe Mrs Donoghue a duty of care. Any manufacturers will owe a duty of care to consumers to avoid causing them harm or producing contaminated drinks. This really set down the duty of care test and widened it so that it applies to anybody who is or should be in reasonable contemplation of the defendant.